Morning, colleagues, and welcome to my presentation this morning, which hopefully will give you a bit of an introduction into the world of supply teaching,
webinar waiting room,
and also we'll talk about the issue of fixed-term contracts. My name is Paul Watkins, and I'm a national negotiating official for the NSWT, and one of the areas I have responsibility for within the union is obviously the work of supply teachers, and also other areas as well. So hopefully I'll take you through the slides this morning and give you some understanding, hopefully, of the situation, covering all the different nations, and hopefully there'll be some time at the end to take some questions. If you do want to ask a question, then do submit it in the Q&A box as opposed to the chat box, but I'll try to monitor both as best I can so that I can pick up on any issues that people have or any questions you have. And if there are questions at the end that I'm unable to answer at the present time, then certainly I'll commit to taking those away and getting back to colleagues as best I can. Without further ado then, next slide, please. Thank you. Okay, so for just to illuminate a little bit on the main routes into supply teaching, particularly obviously for colleagues who work in, say, England and Wales, we'll address issues regarding colleagues in Scotland and Northern Ireland a little bit later on. But there are really three main routes into supply teaching. So you could work directly through a school. Obviously, you go to the school directly employs you and engages with you, and they pay you accordingly. You could work for a local authority pooled supply. So local authorities may have a bank of supply teachers. You register with the local authority as a supply teacher. They then take bookings from schools, and schools then will seek to liaise with you and through the local authority pooled supply arrangement to book you for an assignment. Or obviously the final one, which is by far the most frequently reported way to secure work, certainly over the last number of years now, is engagement through a supply agency. So you will go to a supply agency, you'll register with them, and basically they take bookings from schools rather than schools book you direct or book you through a local authority pooled supply arrangement. And next slide, please. Thanks. So hopefully colleagues can see this. Okay, so as I was saying, direct employment essentially is a two-way relationship. You will go to a school, you may submit them with a CV, you may submit them with a letter of introduction, and they may decide they want to engage with you, and they will issue you with an employment contract for the assignments you do, whether they are short-term, ad hoc daily assignments, or whether they're more long-term, frequent assignments, say for weeks, months, etc. Now, the beauty of this relationship is that you should be paid according to some level of scale, based on the school's pay policy. So that's a very important thing to understand when you engage. It's what's their pay policy. And a lot of schools now do put a majority of their policies on their website, so do look. And also another significant advantage of this, which many of our supply teachers working through agencies would love to have, is that you would be paid into the TPS or Teachers Pension Scheme, because there is a legal obligation on the employer to enrol you into the scheme that it operates, and the vast majority of schools, as we know, operate the TPS or Teachers Pension Scheme for those people working in their schools. So there are two significant advantages to this. As I've said, you will be employed on an employment contract directly with them, you will get paid to some sort of scale, and you will access the TPS. So the other example then, as we discussed in the previous slide, was working through a local authority pooled supply. This seems to be something that, whilst it does still exist, has diminished over a significant number of years. So it's now the case that these don't exist in the vast majority of local authorities, but there are some still out there. For example, Worcestershire, whilst it's operated by a private company, it still operates a sort of local authority pooled supply. So if you undertook supply in Worcestershire, for example, you would be paid to scale and you'd have access to the TPS. And schools would book you through this third party for an assignment. So basically, this would work in the sense that you'd sign on with the local authority would have the contract with you, and the schools would have a list or bank, as it's commonly referred to, of supply teachers for which they can look at and they can access and they can draw upon when they need supply. So again, the advantages of this scheme, if it does apply in your local authority or in the areas where you work, is that you would be employed in terms of pay to scale, and also, well, that would be the school's pay scales, obviously, but you'd also be able to access, again, the TPS. So again, significant advantages to this, as opposed to working through an agency and or umbrella company. And we'll come on to that with the next slide now. The other thing to say about working for a local authority is that you will be able to pool your resources, in the fact that once you've registered with the local authority, it's it would be the local authority that would then provide the details of who you are to the schools. So rather than you having to engage individually with each school, the local authority would sort of do that for you, and therefore they'd be accessing more opportunities potentially for work for you. Okay, so as I said there, better economy of effort potentially, in the sense that you're known to more schools, but you haven't actually individually, personally gone to all of those schools to engage with them. So, as I said, this is by far the most frequent way in which supply teachers are employed. Certainly, surveys that the NSWT conducts on an annual basis would suggest that over in excess of 80% of supply teachers, I think it's about 88%, have suggested the only way in which they can secure work is through an employment agency. So basically, you are going to an employment agency that is a private company that operates a business essentially of securing work for its work seekers, and they then take some sort of profit and charge a commission to schools, and that's their business model. Okay, so it essentially operates in this way. So it's what we sometimes refer to as a tripartite relationship. So you are registered with the employment agency, okay, and you will have a contract. You may have a series of separate contracts. I think it's important to understand that, but you will have an overarching employment contract with them. Normally, it is a contract for services. It's not a contract of employment, and that's different in terms of the way you're treated in law and the employment status.
I'm struggling to work out what the problem's been this morning.
Okay, so employment, you would register with an agency, and then when you register with the agency, you supply the services to the school. When the agency has secured you work, the school then generates a timesheet and generates an invoice, and that invoice then is paid to the agency. The agency deducts what it needs to deduct for you, and then obviously the remainder of the money is yours, and that's the pay that you receive. Okay, so it's introducing another layer of complexity, you could argue, into the employment relationship, because you're no longer employed directly, as you can see there, just two parties. It's now another party involved in the situation, and that party's aim is to make money off supplying you for the work you do. Okay, so if you talk about the local authority in the previous slides being in this situation, local authority isn't taking that level of fee commission, because essentially a lot of their money for running pooled supply would be money that's been given to them by schools and their local authority to manage the arrangement. So they're not necessarily in the business of making the profit that obviously an agency would be in. So it's important to understand then, when you are employed by an agency, if this is the model and the way in which you are securing work, there are no national pay and conditions for supply teachers. Whereas if you're employed directly through a school, or you're employed through a local authority pooled supply arrangement, there are still obligations that they must stick to and adhere to in terms of the school teacher's pay and conditions document, if they adhere to those, and there are regulations around the treatment of supply teachers and the way in which they should be paid. So there is no national framework in that way if you're employed by an agency. So agencies are free to pay you the level that they think is appropriate, and that doesn't mean necessarily that you would be paid to scale for the work you undertake. So as is often the way, a lot of supply teachers working in this arrangement will say that their pay hasn't been increased significantly for a number of years. And they're concerned, obviously, that if they do want more pay, then obviously sometimes the work sort of diminishes or dries up. So it is difficult when you're employed by an agency, because agencies will set their own pay and conditions. And that can be complicated further by the fact that there are agencies out there that are national agencies. So you would, for example, talk about Hayes, Connex, and they will have, say, regional branches, and even within the regional branches. So if you work in, say, a regional branch in Devon, you may be paid less than if you work for Connex in Gloucestershire, because the market is different and the market for supply teachers is different. So there are differences within those national agencies, as well as between different agencies, and that obviously can further complicate matters as well. So the backdrop to a lot of this is general employment legislation. We'll talk a little bit more about that on the next slides coming up. So the agencies essentially, as I articulated previously, they will charge the school a day rate when they provide you to the school. And obviously the amount they charge is greater than the amount that you would receive, because their business model is such that they charge, say, £200, and obviously they then take a commission, and that's their business model to keep their business going. And so obviously their commission then gets deducted, and all the other deductions they need to make by law. And then obviously the payment you receive at the end would be the payment that's yours in terms of your daily rate. So when you look at this, if you're employed through a agency, you are by definition considered to be a worker and not an employee. I think this is a very, very important thing to understand, because the distinction is significant when you talk about your rights and entitlements. Okay, so as a worker, you don't access and have the same rights and entitlements as you do if you're an employee. Okay, now it's different to being, say, self-employed, because obviously when you do work as a supply teacher through an agency, you are supplied on a temporary work arrangement. You're undertaking temporary work, but you are supplied under the supervision, direction and control, or what we sometimes call SDC, of the hirer. Okay, so you have a contract with the agency, and that contract is to perform work or services personally for them, and you're engaged, and you go to a school, and the school will tell you what to do. It supervises, directs and controls you. And the reason why I've just articulated that and highlighted that is because it's important to understand this is a distinction in law between, say, an agency worker, an employee, and somebody who's self-employed. Self-employed people would have, say, for example, the right of substitution. So they could send somebody else to do the work. And some of you may have experienced that if you've ever booked a builder to do work. One day it's this builder that turns up, the next day it's another builder, because they do have in law, if they're self-employed, the right to substitute and send somebody else. Clearly, in a school situation, if you've booked a supply teacher, you don't expect their mate to turn up on the day, so they don't have that ability to substitute, and they are quite clearly under the supervision, direction and control of the hirer, which would be the school. Okay, so the hirer is the person who employs you for the assignment. Okay, it's not the agency is the agency. So the hirer is the school in most employment situations, because they're the people who booked you for an assignment. Okay, and they're the people who'll be telling you what to do on the day, and they'll be supervising and directing you when you undertake your assignment, in the shape of saying what classes you're covering, when you're covering them, and where you're covering them, and what they may even expect you to do on the assignment. Okay, so we do have another party coming to the arrangement sometimes, and it's a common question that's asked, a role played by umbrella companies. And it's interesting to note that only last week the government has announced a consultation around the use and abuse maybe of umbrella companies in the market, and what their role is and what they do. Hopefully this diagram should illuminate a little bit of what they do. It's another cog in the wheel, and essentially what often happens is your agency may employ you, and what they may do is they may then farm you out to an umbrella company. And so essentially the umbrella company assumes the responsibility and role for employing you. And what the umbrella company then does is the umbrella company then generates things like the invoices, etc., and pays you accordingly. So it's a very good question to ask, well, what's the purpose? And a lot of the time, the purpose is that the agency is seeking to avoid some of its obligations and responsibilities. For example, payroll functions and other issues like paying you your deductions of national insurance, etc., like that. So they are farming out to the agents, the umbrella company, because it's more convenient, because it saves them money on their payroll function. Now, of course, a lot of our supply teacher members, and we certainly advise supply teacher members working that they should try to seek to be paid PAYE through the agency and try to cut out the umbrella company. Unfortunately, in law, it is not illegal for an agency to say they want to use an umbrella company, and the agency can say, well, it's either sign up with the umbrella company or we don't provide you with work. Such is the nature of your employment relationship. The agency is under no legal obligation to find you work. So you can shout and scream that you want to be paid PAYE. It's reasonable. Totally understand that. We advocate it ourselves. But the agency might say to you, well, yes, that's fine. This is the model we operate. So if you don't go through that model, we're under no obligation to find you work. Okay. So it does introduce another level of complex, another level of the complex nature. It introduces another layer, as it were, to the employment relationship. Hypothetically, though, there are some advantages, and I did say the word hypothetically because research has suggested a lot of supply teachers don't reach or acquire these advantages. But sometimes when you're employed through an umbrella company, you're actually employed as an employee, not a worker, which means obviously you can potentially gain access to more employment rights. But the reason why I say these are hypothetical is because often you're not employed for long enough to actually be able to access these rights. So whilst in law it seems like you can achieve them, the reality on the ground is you never achieve that level of service to actually, the eligibility criteria, you never meet those in order to actually gain them. So it is complicated. And obviously, we will be issuing some advice and guidance to members about the consultation and suggesting that members obviously write into that consultation on a number of questions which are specific to you as an individual working in a situation like this, to raise those concerns about umbrella companies. It was the plan of the government to legislate, to regulate them, and that's still something that's in the pipeline. But obviously, up until that time, when that legislation comes in, it is still quite tricky because nobody currently regulates or legislates for umbrella companies. With agencies, there are bodies that we can report uses and abuses to, but obviously there's nobody we can report the same thing to for an umbrella company because there is no regulatory body currently at the moment. So you may have, as I've hopefully explained, an overarching employment contract with an umbrella company where they treat you for tax purposes as an employee. Okay, but as mentioned previously, the main benefits of this is that it's often not a benefit to you as a supply teacher. It's a benefit to you it's a benefit to your agency because they may be able to avoid some of their obligations. And certainly what we've seen with umbrella companies and the contracts they issue is we've often seen contracts where they say they will agree to pay you at least the national minimum wage. So they don't actually set what the daily rate is. They say that's it. And we've had issues around the way in which they pay you. So often they will talk about things like discretionary bonuses or a loan. One of the things that we were certainly exposing and seeing during the whole COVID-19 pandemic lockdown and the coronavirus job retention scheme, with supply teachers working through agencies being placed on furlough, was those that were employed through a number of umbrella companies were often only getting 80% of national minimum wage, not 80% of what they were earning, because the remainder was often paid as a bonus, and the regulations didn't allow payment of bonuses for a specific period of time. We campaigned on that, and we got the regulations changed. But it did throw up this really, really convoluted employment relationship and the way in which umbrella companies operate. So just to elaborate then a little bit on what a supply teacher journey would look like. So it's important to understand. I don't know what the knowledge base is in terms of some of you and your experiences, but a lot of people talk about something called AWR, or agency workers' rights. Okay, they are quite important. They are very significant, and particularly after 12 weeks of employment with the same employer, they can kick in and give you significant advantages financially in terms of access to the same level of pay. However, for a number of supply teachers doing ad hoc daily assignments who may not achieve that 12 weeks qualification period, the most important regulations that protect you and cover you and regulate agencies are what are known as the conduct regs. Okay, so they are the sort of regulations that you get from day one. So it's important to try and understand the supply teacher journey. So depending on what you're doing, how you're doing it, the length of time you're doing it for, will dictate whether you're accessing those rights after 12 weeks or whether you're accessing rights under the conduct regs, which are rights you will continue to have straight away, and those day one rights as well under the agency workers regulation. So I'll talk a bit more about those, and then obviously we'll keep going. So the conduct regs, they basically they are the key terms and conditions, and they establish the way in which agencies operate, and also to some degree the way in which you operate. So there is a requirement for you to provide information, say bank details, proof of who you are, your identity, etc. Proof that you have maybe the rights to reside in the UK, which is a Home Office requirement. There are requirements that place an obligation on you to provide information under the conduct regs. And those are standard things that an agency would engage with you on when you register to work through them. And seek supply work in that way. But the conduct regs also are quite significant in terms of they place obligations on the agencies in terms of how they operate with you and what they must say to you and what they must provide you with. They were updated back in 2020, so they've continually been updated to reflect changes. One of the changes was to reflect the fact that we weren't in the economic area following Brexit, but one of the changes in 2020 was an introduction of something called a Key Information Document, or KID, and we'll talk about that a bit later as well. So, as I said, basic information that you as the agency worker going to a supply agency wanting to work through them are required to provide are issues like your bank details, proof of ID, personal information to prove who you are, because there will be checks that they are required to be undertaken, and your training qualification, and quite significantly there, obviously, a DBS. And in regard to DBS, or Disclosure and Barring Service, for supply teachers, we'd always recommend that you register with the update service, which is a bit more portable. And if you register for that, then basically it's very easy for supply agencies to see that you've been cleared to work, rather than have to go through a situation where you constantly register with an agency and they charge you a fee to do a check on you for purposes of DBS. So register for the update service, and that will provide you with more security in terms of them being able to access that information on you more readily and more easily. Okay, so here are some of the pieces of information the agencies must provide. Okay, so they must, they must be obtained before the assignment is given. So they must state they're operating as an employment business. They must identify the type of work that you provide or that you are seeking. So, for example, you're seeking teaching work. And this is quite significant, because if you go to a school, the school then says, well, we booked you for teaching, but the teachers managed to struggle in today, so there's some cover supervisor work. Well, that would require a separate assignment to be drafted, to be provided to you, and to document quite clearly the rate of pay you would or would not be willing to accept. If you go to that school, you undertake cover supervisor work, but the contract for that particular work said you were teaching, there is an expectation you'll be paid the teaching rate. It's not your problem. You were supplied as a teacher. They've changed the rules, as it were, of engagement, and therefore they should issue either another assignment document, or they would have to pay you accordingly. We do see this happen quite regularly. So if there are issues around that, and you've experienced that, and you are asked definitely and distinctly to be a teacher in school, you go there, you do cover supervisor work, there is an expectation you're paid accordingly as a teacher at the rate you agreed with the agency. And if you have an issue with that, or experiences of that, and you feel that wasn't the way you were treated, do come to the union, we can take that up. We have pursued these things, and we have been successful in terms of our dealings with the regulatory bodies who've made it known to the agencies that that's not the way it should be done. And as a consequence, they've had to reimburse our members for any deductions because they didn't pay them accordingly. So point number 4 there, the agreed rate of pay and how you'll be paid. And again, how you will be paid, it does sound trivial, but it is very, very, very important. Because obviously if you're paid weekly, you should be paid weekly. If you're paid monthly, you should be paid monthly. Yeah, and the agency cannot use the excuse that the school didn't pay them as a reason to not pay you according to your contract with them. So if you're agreed to be paid weekly, the agency says, well, we are struggling to get information from the school to pay you this week, then that's not acceptable. It would be seen as a breach of your contract with them because that's the way in which you've agreed to be paid. And obviously the agreed rate of pay as well. So if you've agreed the rate of pay of £160 and you've never had any information to say that the rate for the assignment you undertake is different and less than that, then obviously you will be paid the £160 you've agreed because that's the arrangement you have. And again, we have dealt with supply teachers where they've informed us that the rate of pay they got for assignments with an agency was on a regular basis £20 less than they'd agreed to be paid. And we did get them, off the top of my head, I think they told us they obtained about £500–600 in back pay because we presented an argument that's not the way it should work. That's a breach of the conduct regs, and as such, they were paid reimbursed. So again, point number 5 there, and I do have this habit, so apologies. I will often talk about the thing that I'm about to talk about coming up. I'll talk about it before I get there. But you must be paid for all the work you've done, even if not paid by the client. It's a really key fundamental issue. So if the agency hasn't received the money from the school or schools where you've worked, it's not your problem. It's not a reason to not pay you. Okay. You may feel it's pragmatic to say, okay, I'm okay with that. I can wait. However, the arrangement is such that if you agree to be paid every Friday of every week, then if the school's not received that money, that is not your problem or dilemma to face. There's still a relationship there with an expectation of payment. The contract you sign as well, and this is important, and we'll talk about this in the context of a key information document in a minute, but it should detail deductions. It should detail where your holiday entitlement is and how they will process your holiday pay. So it should detail all of those things. And it also should detail, so the overarching contract you are given should detail any notice periods. This is a common concern agency workers have when doing school work through a supply agency, is they often get told when they get there, they're no longer needed. They've not got the chance to secure another assignment. But look at your contract. It often will say there's no notice period. Now, that often appears to work to the advantage of the school and to the agency because they can just cancel an assignment you're on. But it can also, to some degree, work to the advantage of the supply teacher working through an agency, because if they arrive at school and the school is so disruptive and they don't like it, they can walk. And what you could do is you could walk, or you could enter into negotiations about, well, I will stay, but I want more money. So it does also serve the purposes of the agency worker as well, because they can walk as well. Okay. If you are on longer term assignments, there is a suggestion, if you are on long-term assignment, you might want to negotiate some level of notice period, maybe a week, etc., with your agency and the school, in order to, if suddenly somebody comes back to work earlier than anticipated, so the assignment's not going to last as long as it was intended to, you can then go and find secure work elsewhere in that week period where you've got a notification or notice period, the assignment's going to be cancelled. Okay, so the role and rate of pay, I think, is quite important to understand. It will depend on the nature of the job and what you're willing to accept. So you will have, as I said, an overarching contract, but then you may have a series of separate contracts to reflect the assignment you've done. And of course, some people sometimes will chance their arm and try and get you to do cover supervisor work. The agency should inform you of that and should inform you of the rate of pay if it's different. If they don't, go back to what I said previously, as an argument, you should be paid accordingly to what you are agreed as the rate. Okay. The other thing to bear in mind as well when you look at your contract is how they are going to pay you. So yes, weekly or monthly, etc. But what is it? Is it a daily rate or is it an hourly rate? Certainly, when I was starting in the role, looking at this back in 2015, most supply teachers, I would have argued, were paid on a daily rate, which is good. And it's unique to teaching as opposed to other work where people do work through agencies. Because essentially, if you've got downtime in a day, so you're in a secondary school, you teach periods 1, 2, no work period 3, and then period 4 and 5, you will still get paid for the whole day because it's a daily rate. Now we're starting to see a number of agencies use what we would call an hourly rate. So if you take that same example scenario, if period 3 there is no work, you don't get paid because you are paid for the hours you work. So it'd be important if you are on that rate and you go to school and they don't have a teaching role for period 3, is to find something to do so you are undertaking work. That could be potentially offering to do some photocopying for somebody, I don't know, but what you want to do is ensure that you aren't sat there in the staff room twiddling your thumbs during that hour, because technically the school will say, we didn't work that hour and the contract is an hourly rate, so we're not going to pay you for that hour. So you are paid for the hours and the work you undertake. So try to maintain a daily rate if you can, because that ensures you will get paid for downtime, even if you don't work, because it is a daily rate. So other key things to spot, as I said, termination dates, notice periods. So do you want a termination date in there? Do you want a notice period? So again, if you're on longer term assignments, do look out for this. Do try and insert that clause as and where you can. Okay. Finder's fees. Often within your contract, your overarching contract of employment, it will dictate that the school can be charged what's called a finder's fee, or sometimes a transfer fee to by the agency. Essentially, you are the agency's commodity. I'm being quite blunt about it, but I suppose it's a very simplistic but useful way of looking at it. But you are their commodity and you are their source of income. So if they lose you to a school, so finder's fees often relate to situations where you go to a school, you're doing a very good job, and an assignment or a long-term assignment or even a permanent appointment transpires and comes out of this. The school want to take you on. Now, because the agency is losing you as a commodity, they can charge what's known as a finder's fee or a transfer fee. Okay, and that should be in the document. It should be in your document you get, and it should be in the assignment details that they give to the school as the hirer. Okay, often I think the foot of blame for some of the misappropriate use of finder's fees, the foot of blame does lie with some leadership groups who really should negotiate a discounted rate, because they could say, well, I won't pay this, I'll pay that instead. So it's important to understand an agency can only charge a finder's fee if they offer you in the contract that they give to the hirer, they must offer the hirer an option of an extended period of hire. So basically you can be taken on for longer, and by being taken on for longer, you can go there for free. So they must offer that in the contract. So if that's not in the contract, they can't then impose a finder's fee. And the other thing is finder's fees are not supposed to be so unreasonable as to prohibit you from potentially getting permanent employment. Okay, and we do see that quite regularly. So particularly for school leaders, where they're doing work through an agency in a school, they often will issue, it's like 60% of the annual salary. And we would make an argument that's prohibitive, it's unreasonable, because it's too much of a barrier for the school to be able to hire you permanently. So do watch out for that, and it should again be in your contract in terms of if they are going to charge a finder's fee or transfer fee, the level at which it should be charged. And just to point out, as I said earlier, it can be negotiated by the school. Finally, the other thing, and this is very, very specific, but it's very true. The agencies you may be engaged with, or particularly umbrella companies, sometimes chance their arm and say to you, you can opt out of the conduct regs. That is not true. And it's not true because the conduct regs, in some work areas, say construction, etc., where you might be working on a building site through an agency, you can opt out the conduct regs, but you can't opt out of the conduct regs if you work with the vulnerable. And obviously by vulnerable, that is encompassing of school children and children and young people. So that is a provision where you cannot, so your agency cannot say to you, oh, opt out the conduct regs. Because essentially what they're doing is saying to you, opt out the conduct regs, you can't challenge us over X, Y, and Z because the conduct regs don't apply. But they cannot do that. So if your agency and or umbrella company say or offer you that, just a very short response to them saying, my understanding is under the conduct regs, because we work with children and young people who are classed as vulnerable, the regulations do not apply in terms of the ability to opt out. Off the top of my head, I can't remember what the regulation is, but I think it's something like 32C or 32B. But if colleagues want, I can put that, I can make sure that information is in the slides which are sent out following this. So they can't do it. And I have engaged with a supply teacher member of ours recently, where the umbrella company was really trying to say, you need to opt out the regs. And I had to say to them, just tell them they can't do that. And we have identified that agency umbrella company and we've reported it. There you go. See, 32. What did I say? 32C. What load of tosh? It's 3212. Yeah. So regulation 3212. I did get the 32 bit right, so I'll give myself some credit. Okay, so it's a regulation 3212. They cannot opt out. It's not an option because you're dealing with the vulnerable, and vulnerable children, children and young people will be defined as being vulnerable. Okay, right. So we move on to this interesting thing called a KID, or Key Information Document. So from the 6th of April 2020, recruitment agencies were legally obliged to provide anybody who was a new agency worker, important distinction there. If you're still working for an agency prior to this, they don't have to provide it. But if you are working for an agency and you're registered with them, you should be provided with a key information document, which was designed to drive up transparency. Okay, and regulation 13A of the conduct regs expects that you are provided with a key information document, and it should document a range of things. So it should tell you, for example, are you being employed by the agency and or an umbrella company? Okay, and it could be the case that there are 15 different umbrella companies an agency uses, and I have seen a real life example of that. So they would have to give you a KID for each one of those umbrella companies, telling you how you'd be paid, what the deductions would be, etc., etc. Okay, so who employs them, details of who's responsible for paying you, any fees that are to be deducted, because agencies can charge you for providing you with training, etc., and checks, say for DBS if they have to, which is why the update service is fundamental to be on. And so they should provide you with all of this information. They should also tell you about your entitlement to annual holidays, associated holiday pay. And lastly, at the bottom, which I think is a really important point, they should provide you with what is described as a real life, not a made up hypothetical illustration of what you should be paid, but a relatively realistic illustration of the pay they expect you to receive. And if the agency allows you to be paid through them or through an umbrella company, they have to provide you with separate KIDs detailing the pay with each. So the idea of driving up transparency was all about you being able to see this on a document and being able to read and make a judgment, a more informed choice about how you want to be working and how you want to be paid. Whether that is in reality, happening, because we certainly get, I think about 23% of supply teachers to our most recent survey said they weren't provided with a KID. And I think disturbingly, we've had about 48% said they didn't even know, they weren't sure. And it should be really obvious if you have been provided with a KID. Okay, it's a document, it's supposed to be a legal document, it's supposed to be written in a certain way, it's supposed to be a certain size font, so it shouldn't be so small that you're going to need glasses when you try and read it, because it's so small you can't read it at all. Okay, and it's supposed to be provided with you as part of a day one sort of right in terms of the information that's provided with you, for you to make an informed choice. Okay, so when we talk about a sample statement of what you're going to be paid, it must be reasonably realistic, and it must include, say, your gross amount of pay, any statutory deductions that the agency and or umbrella have to make, so national insurance, employers, NIs, etc. Non-statutory deductions, because they may make deductions for other things, That could be because they've provided you with training, so they're deducting an amount per week or per assignment for that training that they provided you. Any fees charged or for goods or services, so if they are charging you for anything, what they might charge you for. And obviously, lastly, more importantly for you, is what you are likely to receive as the net pay. So you should be provided with that through a key information document so you can make a more informed choice. So we then come on to the agency workers regulations. So they were introduced back in 2011 to ensure agency workers are treated in the same way as directly employed workers carrying out the same work. Now, as I showed you in the journey, there is what we call day 1 rights, and there are day 12 rights. So day 1 rights include things like you should have access to the same amenities and facilities. So, for example, if there's a staff room, you should be able to access that staff room. You should be able to access the toilets in the staff room. You should be able to access the microwave in the staff room. You should be able to access the fridge. Seems really ridiculous, but we do have experiences where supply teachers say, I wasn't able to use this. And when we say why, well, because I was told I was just a supply teacher, it's not available for us. That is a breach of the AWR, because that's a day 1 right, access to collective amenities, facilities, etc. The other thing within that, by the way, which seems a bit pedantic, but is right, because a lot of supply teachers complain, is car parking facilities. So we do get supply teachers who tell us that I had to park outside the school and my car was vandalised. Whereas if I'd parked on the school site, it wouldn't have been vandalised because there's secure units, it's gated, etc. Okay, the school cannot prevent you from using the car park because it's a facility, it's an amenity, and you are legally under the AWR entitled to use that for a day 1 right. So again, if the school isn't allowing you to do it because they are saying, well, that's for our permanent staff, sorry, then that would be considered a breach of the AWR, particularly day 1 rights. So as I said, day 1 rights, and the most frequently discussed or talked about are the rights people have after 12 weeks, because those are the ones that are more significant and important, because they're the ones that relate to being treated equally in regard to pay and some other conditions as well. So yeah, so when you get your rights after 12 weeks, the right to equal pay, it's important to understand that you would want to seek the pay policy of the school to understand that, and you would also want to understand what is a comparable employee. So there is an onus on you if you think after 12 weeks you should have a pay increase because you're doing work that's equivalent to somebody else. You'd want to make sure you document what exactly it is you are doing or have been doing to guarantee that you are working to that comparable employee level. Okay, so, and you'd want to understand the pay policy of the school to understand where you think you are and what you think you've been doing and the work that you've undertaken. It's important to understand, though, that when you get these rights to be treated in the same way, those rights do not extend to occupational schemes. And I think it's important to understand that because it means it doesn't relate to occupational sick schemes. So there is a sick scheme for school teachers called the Burgundy Book, which does provide teachers who've got 4 years or more continuous service with 100 days sick leave on full pay, followed by 100 days sick leave on half pay. That doesn't apply to agency workers because it's an occupational scheme. Likewise, the teachers' pension scheme is an occupational pension scheme, and it wouldn't apply that you could access that after 12 weeks. So there are some important exclusions from it. But a lot of this information, if you have further information you require in regard to these specific regulations, then there is information on our website, and obviously do take your time to navigate the supply teacher section of the website, or do come back to us on any questions or queries regarding this. For my screen froze then, had a massive panic. When we talk about supply teachers in Scotland, and we talk about, say, issues regarding teachers in Scotland, then obviously probationary teachers, you can gain access to registration through 2 different routes. And obviously the one that might apply to people who might be doing supply work would be the flexible route. Okay, so but the flexible route has some issues or complications with it, in the sense that the onus is on you as a teacher if you're trying to gain your status through that route in Scotland. The onus on the teachers to source their own employment on a temporary basis, and so we would always recommend it best that you try to source work through the teacher induction scheme, which gives you that provision of a guaranteed post. So it's important just to understand there are distinctions within the different nations. So, and obviously in Scotland, the way in which supply operates is very, very different as well. It's operated by the SNCT, and it's operated through local authorities, and there are set rates of pay. And the SNCT makes a distinction between a short-term and long-term supply. It classifies short-term supply as supply that's no longer than 2 days. And obviously, if you are working longer than that on supply basis, then there is a suggestion the councils and the schools are responsible, and the onus is on them to ensure that they're providing you with some sort of fixed term contract, which specifies the nature of the contract, the extent in which you're working. And obviously that would assist you with the flexible route, because it will give you some level of time frame for which you're working, and obviously help you in terms of the qualification period. Okay, so there we go. That just clarifies the situation. Yeah. So both the head and local councils have responsibilities in how this is managed, including reviewing or renewing or issuing fixed term contracts, and ensuring this time is recorded accurately for any pay increments you may be able to access. So it's a very, very different system in Scotland in terms of the way you're employed through supply. It's a far better system, I would certainly argue, than the one we have in Wales and England. And obviously, you need to bear in mind how that then factors into you as a young teacher qualifying and the qualification period, etc. For Northern Ireland, they are not called supply teachers. We refer to them as substitute teachers. That's the moniker that they have over there. And schools are employed through the Northern Ireland Substitute Teachers Register, or what's commonly referred to as NISTRA. Okay, and again, all teachers who are operating through that must be registered with the GTC, General Teaching Council Northern Ireland, who approves qualifications, and NISTRA will check to see that you have that qualification in terms of being registered on there to undertake work. And again, the general rule of thumb, if you're working through trying to secure some teaching route through being a substitute teacher, is it is more complicated and convoluted than trying to achieve it in the more what would be perceived potentially as the more normal way of the route into securing your induction, etc. Okay, so it's operated and agreed by teaching unions and the Department for Education, and any changes that are proposed must be agreed. The trade union side can put forward proposals and they're put to the employer, and obviously the employer, if they agree them, then they do become a new TNC agreement. So part of what I was asked to do today was also to talk about fixed term contracts. I'm very conscious of time. We did start a little bit late. I think there is some flexibility. So I will keep going until somebody shoots me down and tells me to cease and desist. So fixed term contracts. Okay, so the general position of the NHWT is we don't think it's appropriate for NQTs, etc., to be placed on fixed term contracts. We believe they shouldn't be operating in this way. Fixed term contracts in law really are designed to apply to work undertaken that may terminate on a specific date. So you've been employed to undertake a task. The task is done, the work is finished, therefore the fixed term contract will be terminated. Okay. So it may terminate on a specific date. So it may terminate because somebody is returning from maternity leave on a specific date, or returning for a period of absence, or it may terminate on an occurrence or non-occurrence. So it could terminate when we say the penultimate point there, it could terminate if somebody is on a period of long-term sickness for which you're on a fixed-term contract, and that person then returns a bit earlier, then it could be seen to terminate if there's an occurrence, of them returning to work. Okay. Important to understand that last point. The regulations do only apply to employees. So if you are working through an agency, then there is an argument these regulations don't apply because you're working through an agency on a fixed-term contract as an agency worker. So the best way to ensure these regulations apply to you is to seek direct employment, hopefully with a school on a fixed-term contract, and then you'd be classed as an employee of theirs. And it's important to bear in mind as well, some of the regulations around fixed-term contracts also require some period of qualification. So you will only get access to these if you've acquired some period where you maybe have worked longer than 6 months. So if the contract is only for 3 months, then obviously there is an issue in terms of the eligibility of you in terms of qualifying for some of the provisions of the regulations, which are given the polite title fixed-term employee regulations. So they're the prevention of less favourable treatment. They're slightly different in terms of the name they're given in Northern Ireland, just because the legal process it would go through Northern Ireland is slightly different. So they've got a different name there, but they are essentially the same pieces of legislation and they apply in the same way. Okay, so they were introduced to try to ensure those people on fixed-term contracts should not be treated less favourably than their permanent employee counterparts. Okay, so they provide that where an employee has been on a fixed-term contract or a series of consecutive fixed-term contracts for a period of 4 or more years, a further renewal or commencement of a new contract basically means you are supposed to be able to put on a permanent contract. The proviso being unless the employer can objectively justify a reason why they couldn't do that. And there are a range of reasons to say why they couldn't do that. Please excuse me, I've just got to make sure I put my battery in, otherwise I'm going to die on you. There we go. So essentially, for some people, they may be on fixed-term contracts and they may be on a series of fixed-term contracts. Again, the union doesn't necessarily think that's an appropriate use of the regulations and the use of fixed-term contract, because it does keep those people employed on them. It keeps them hanging on. It keeps them on essentially a bit more like a probationary period, but they're continually on these contracts, and unless the way in which they operate and the work they do is satisfactory to the employer, they'll just cancel the fixed term contract. Whereas if they think it is good, they'll just roll over another fixed term contract. So essentially the regulations are there to try and prevent that. Whether they've achieved that aim or not is obviously a matter for some debate. So if you are on a fixed term contract, you do have the right not to be treated less favourably by the employer in relation to a comparable permanent employee in regard to a range of things. So the contract you're on. So basically, if you're on a fixed term contract, you can't be treated in an inferior manner. And what I mean by that is payment, the hours you work, the way in which you work, where you work, the work you do. Basically, if you're employed on a fixed term contract as a teacher, you should be treated as a permanent employee in regard to teaching. So you should access the same level of PPA, you should access the same rights and entitlements, and you should be paid on the same basis. You should be paid on the same level as an M1 teacher who's a permanent employee if you're an M1 teacher who's on a fixed term contract. Okay, so you are supposed to be treated the same in terms of everything that goes with your contract. Okay. So if a fixed term, and you talk about dismissal and fixed term contracts, if a fixed term contract is not renewed by the employer, then the failure to do so is treated as a dismissal in law, to which any statutory procedures would apply in terms of notice, etc., and any payment that you may be entitled to. But obviously, some of these things do require qualification periods. So as it says in the next bullet point, you will need 2 years continuous service with the same employer in terms of possibly being able to challenge or pursue a dismissal. Okay, because obviously a lot of employment rights don't come your way as an employee until 2 years continuous service. So if you are on a series of fixed term contracts then it would be interesting, because if you're working on a series of fixed term contracts through a local authority, then they are potentially the same employer. The same would apply if you're working on a series of fixed term contracts with a multi-academy trust. If you're in different schools, but the multi-academy trust is the overarching employer, then you could say you would gain that 2 years continuous service if you did 3 different fixed term contracts in 3 different schools under the same multi-academy trust. Okay, then those regulations and rules will apply. Okay, so as I said to you, you may be able to link successive fixed term contracts to form one unbroken period with an employer for the purposes of continuous service. You could bridge gaps in employment potentially. When you talk about fixed term contracts and redundancy, okay, then obviously if you're covering, say, long-term sickness or maternity, then it is unlikely there'll be a redundancy situation. You've entered into an employment situation or arrangement where you know at the end of it, it will come to an end. There is a set date where it ends, and you will be dismissed. You will no longer be required to work in the school because that person's returned for long-term sickness or maternity cover. So you know that, okay? Then it's very unlikely there would be a redundancy situation. However, there may be certain types of situation where there is a redundancy situation, okay? But again, it's about that 2 years continuous service. And on a lot of these issues, read the advice and guidance we have on the website. And if there are issues or questions or queries you have, then come back to the union, contact us, and we can talk to you at length about the issues further. So as I said right from the outset, the union does take a position that we think they should only be used, their legitimate purposes to cover temporary needs. Yeah, so if a school's got specific funding, and some schools back in the day did have specific funding when they may have had a specific status, like a sports college or a language, specialist language or specialist technology, they may have been given certain additional income streams for specific projects. And as such, then they may have employed people for specific tasks which are time limited. And when those things are concluded, then obviously they no longer need those people, okay? And obviously the most common use, I would say, in schools of fixed term contracts are for long-term sick or maternity absence. And when the person returns, obviously there is no use of that person because, you know, they've got the person back. They've come back from maternity leave, etc., or from that period of absence. Yeah. So we don't think there is any sound rationale for using them in the case of newly qualified teachers. Okay, there shouldn't be a situation where they are using them. And when we do see that, then we do challenge it. And so if there are situations or situations where people are aware of that, then obviously those would need to be challenged. Finally, on our very, very whistle-stop tour through everything, lastly, the early careers framework. I just want to talk about this in terms of, particularly in England, obviously, the situation regarding supply, because it is very, very important to understand the situation when you are talking about the early career framework and supply teaching. You know, you are only able to undertake short-term supply teaching for up to 5 years from the award of QTS. That is a limit the government are not going to budge on. They didn't budge on it during the COVID-19 pandemic when we felt there may have been an argument for it to be slightly amended or extended to cater and manage things when we're in lockdowns. But this is not something they budge on, and it's something they believe is quite important. People should seek to undertake, you know, and do their induction within 5 years. The other important point, and again, I think this is very, very important to understand, short-term supply work will not count towards any period for the early career framework, etc. It won't count towards your induction. It has to be a term, and a term is not a half term. So it may be the case that it's quite difficult in some situations for you to achieve a period of supply that's going to actually count towards your induction, because we'd be talking about whole, you know, if you take the autumn winter term this year, you'd be talking about, you know, from September to December. That would be, you know, a term. in terms of the way the regulations are interpreted. So it's very, very important to understand that. So we do think that poses problems for a number of supply teachers who may think that if it's 6 weeks, 7 weeks, it's going to count. The likelihood is it probably won't, because it's not a term under the definitions of the framework. The head teacher or principal or supply agency is responsible, about how you operate for ensuring that a teacher who's not satisfactorily completed is eligible to carry out short-term supply work. So they are responsible for that, and it is not possible to backdate the start of an induction period. Yeah. So again, that complicates things somewhat. And you'd have to ask the DFE, etc., why they decided to do this. But I think the argument quite clearly, as we understand it, is they think that people should be looking to get themselves signed off and get themselves inducted, etc., and get themselves into a career in teaching as soon as possible and not be putting this off. So that would probably be their position on this. If it is the case that you are going to be in a school for a period of time and taking supply work, and it's going to be a term, then obviously there is an expectation, a requirement on those who are dealing with you, whether it be the agency and or the school or both, to put in place an induction program for you, and to ensure that you have access to all those things that other people have access to. It would include things like reduction in timetable, etc. So there are some provisions in place to ensure that you're treated similarly to other people. But I think it's important to read and digest some of the information there, because it can seem like it's more convoluted and complicated to undertake the induction period through a supply route. And the same would apply in Northern Ireland. Okay. The view of the Department for Education in Northern Ireland is that you can do it, and you'd have to, and there's an expectation you need to build up your induction portfolio and the range of teaching experiences you've got, etc., and log your professional development. But the argument is they think it's a bit more complicated and convoluted for induction teachers to participate and to engage with the framework appropriately. So again, it'd probably be better to consider the route into teaching as opposed to through substitute teaching in Northern Ireland. So I have put a lot of useful links in there for people to consider, and I will just say you can go around and play around with the website, have a look at what there is. But that is it. Thank you very much for your patience, particularly at the beginning, and obviously throughout. And just having a look to see if there are any questions in the chat box. I can't see anything. I'm happy to take any questions if colleagues have got any. Otherwise, I would just say a big thank you for listening. I'll make sure that this presentation is provided following the rest of the day today. I hope the rest of today is a success, and I wish you all well and the best luck for your future careers. Thank you very much.
Thank you very much, Paul. Thank you for that fantastic presentation. And I am sorry that I couldn't come on the beginning to welcome delegates and to introduce you, Paul, because you omitted to tell the delegates a little bit about yourself. So I'm gonna jump in and just explain to everybody that Paul is one of our national negotiating officials and very, very knowledgeable, and lots of terms and conditions and all things to do with teaching. And I always learn a lot from Paul whenever he makes a presentation, and I've made some notes and learned a lot today. Thank you, Paul. And also Paul obviously was a teacher, lay official, and came and a national executive member, and is now working for NASUWT. So he has a wealth of knowledge, and he also knows exactly what it's like daily on the ground. So thank you very much for Paul for getting up so early this morning and starting our day, and thank you for saying that that presentation will be available, because I certainly want to be able to make more notes and share it with some colleagues that I work with. So and also what I didn't do just now, I just jumped in. I didn't even introduce myself to everybody. I'm Angela Butler, and I'm the SVP of NASUWT, and I'm going to be your chair today. So I've got a few announcements to make before we break now. One is that updated links for all of the sessions have been sent out, hopefully to avoid the gremlins that we had first thing this morning. So you've got updated links. Please, during this break, have a look at your emails and you know, sort that out for when we reconvene at 11 o'clock. We're going to reconvene at 11 o'clock with the Deputy General Secretary. So we've got a break now. And I think without further ado, really, I'll let you go for your break, sort out your links and everything. And when we come back at 11, then I'll make a proper sort of introduction and set out the rest of the day. So please step away from your screens now, have a cuppa if you can, and look for that email for the links, and I shall see you hopefully on the other side at 11 a.m. All right, so see you a bit later. See you in a bit. Cheers.